Hi, Damon Chetson here for Equine Surety. How many times has this happened to you? You've got a customer coming over to your barn to take a look at a horse. Customer is interested in potentially buying that horse and in riding that horse. You've got that horse all tacked up, groomed, and ready to go. And then you realize that you don't have an equine liability waiver form. So in a bit of a panic before the customer comes over, you go to your office, you get on Google, and you start looking for an equine liability waiver form to print out and give to that customer.
The general problem with a waiver is that courts and judges don't like waivers, and that's because a waiver is a signing away of someone's rights. In this case, the client or the customer, before the client or customer was injured, signed away some of his rights to sue in a court of law to recover based on that injury and based on liability. And so, because the waiver represents a signing away of rights, courts interpret waivers very narrowly. The other problem with a waiver is that just because a waiver may be valid in one state doesn't mean that it will necessarily be valid in another state. For instance, a waiver that could well be valid in Texas or in California may not be valid in Virginia or North Carolina or Florida. So for that reason, simply printing out a waiver from the internet and hoping that it will be valid in all its particulars in your state may not be a wise thing to do. The other problem with waivers is that they sometimes pretend to sign away more than they can. Let me give you an example. Some waivers that I have seen on the internet or even at barns that I've been asked to sign have told me that by signing such and such waiver, I agree to hold the barn or the trainer harmless for any harm that I may suffer while riding a horse or being at the barn. And the problem with that waiver is that it is probably not effective in most states. That's because in most states, you cannot sign away your rights to sue for gross negligence. Now, gross negligence is a higher level of negligence than mere common negligence. Mere common negligence is the failure of the barn owner to exercise reasonable care. And people can be asked to sign away that, and courts will, because of various state statutes, honor those waivers. But most courts are not going to honor a waiver that has the client sign away his rights to sue for gross negligence. A good example of gross negligence might be, let's say you have a riding ring, and in that riding ring you have a huge ditch, and you are perfectly aware of that ditch, and there are rocks in that ditch, and somebody gets thrown from the horse, and because you haven't repaired the ditch, gets harmed in the ditch. That might be an example of gross negligence. Or let's say that you have a horse that you know is a dangerous horse, and you have had people thrown from that horse in the past, and yet you put a customer on that horse, and that horse goes out and throws that customer, and the customer's injured. That might be an example of gross negligence. In other words, you had much more reason to exercise caution. You didn't exercise any caution at all, and the customer was injured. Those sorts of injuries may be injuries that a customer could recover on, even if the customer has signed a waiver. Now you might say, well, I'll just have the client sign a waiver in which they agree to hold me entirely harmless for any injuries, and we'll let a court sort it out later. The problem with that is that a waiver that purports to have somebody sign away their rights to sue for any injury may be thrown out entirely by a court, and so it may not even be effective even if the injury that the client suffered was a result of your mere negligence. So you should look at your waivers very carefully with an eye to how they're being worded and to what they're signing away. In addition, I have been at many barns where I have been asked to sign waivers, and where, when I've been signing the waivers, the barn manager or some employee at the barn says, oh, don't worry about this. It's just a waiver. It's nothing important. Well, the problem with saying that when somebody is signing away a waiver is that it actually is very important. And it is important that the client who is asked to sign that waiver realize it's an important signing away of rights. And when you or your employee tells the client, well, don't worry about it, it's really nothing important, and if that client is later harmed, that client might very well go into court and say, yes, Your Honor, I did sign this waiver. That waiver would be valid, but when I was signing away those rights, the trainer or the trainer's employee told me not to worry about it. It wasn't important, and so I didn't think anything of it. If that's the testimony, and if that is the evidence, and the court believes that evidence, then the waiver may not be ruled effective and may not save you from liability. So for these reasons, when you're thinking about waivers, when you're looking for a waiver to sign, when you're having somebody sign a waiver, you need to be careful about how you proceed. Now, one of the things that equine surety seeks to do is to provide people with this kind of information and with what we think are better drafted waivers that might be applicable in your area. If you're interested in getting some more information about our services and how we can help you as a trainer, feel free to contact us at www.equinesurety.org or by calling us at 919-352-9411.